John F. Koenig has been an elder law attorney since coming to Wisconsin in 1996. He helps clients protect and preserve their assets from the costs of an extended stay in a nursing home. What is elder law?
That's a good question, Susan. Elder law is that area of practice where we deal with the legal concerns of the elderly and their family. We're dealing with areas of estate planning such as guardianship, protective placement, wills, trusts, powers of attorney, including Medicaid, Medicare issues, and Social Security issues, just to name a few.
You mentioned Medicare and Medicaid. What's the difference between the two?
Yeah, Medicare and Medicaid is the government's programs to help the elderly, blind, and disabled pay for their health care needs. But they're two completely separate programs. A simple way to think about it is Medicare is your health insurance and Medicaid is your long-term care insurance. That means that Medicare is going to pay for your doctor's bills, your medicines, and your stay in a hospital, where Medicaid is going to pay for a long-term stay in a nursing facility.
Why is it important to plan for long-term care?
Well, Susan, all of us know that our cost of living are increasing daily, and healthcare costs have risen dramatically over the past few years, especially when it comes to a long-term stay in a nursing home. In the state of Wisconsin, the average cost of a stay in a nursing home is over $75,000 a year. That's more than $6,000 a month. In order to be able to pay for that, someone's going to need to have over $1 million of investable assets just so they can produce enough income to pay for their stay in a nursing home.
What options does someone have in paying for their long-term care?
There's basically three options to pay for your long-term care. First of all, we've already talked about having enough money to pay for your care. Just write the check and don't worry about running out of assets. The second option is to transfer that risk to someone else, an insurance company, through purchasing a long-term care policy. Now, these policies are not very familiar with some people, but when we look at the insurance statistics, we find out that 1 out of 200 people will need to use their homeowner's insurance during their lifetime. 1 out of 15 people will need to use their automobile insurance. And when we look at long-term care, it's actually 1 out of 2, or 50% of us, will end up with a long-term stay in a nursing home. And those stays average between 3 to 5 years. And then our third option is, of course, to spend our assets to qualify for Medicaid.
So how does someone qualify for Medicaid?
Well, when we consider Medicaid and qualifying for Medicaid, we have to realize that Medicaid is a federally mandated and federally funded program, but it's run and administered on the state level. So we really have to look at federal law and state law when we're considering qualifying for Medicaid. Basically, there are two tests that must be met, and we have to meet both of these tests before we're eligible for medical assistance or Medicaid. The first test is an income test. With the income test, the state looks at how much money you earn, what your income is every month, and compares that to your cost of care. And this test is rather simple to meet, because if your cost of care is more than your income, you've met the income test. But we have to remember the other side of the coin is the asset test. And with the asset test, we look at what assets will be considered available and what assets will be considered exempt to be used to pay for your long-term care. For a single individual, the asset limit is only $2,000. For a married couple, it's $50,000 to $104,000, depending upon the amount of assets that you have. All of the other assets that you own above those amounts would have to be spent on your care prior to qualifying for medical assistance.
So, John, what assets are exempt?
When we look at exempt assets, we have to remember that an exempt asset is not countable or cannot be considered available to pay for your care in a nursing home. The basic exempt assets are your home, the house you live in, one automobile, your life insurance up to a face value of $1,500, your prepaid burial or prearranged funeral, as well as your personal property. All your other assets are considered available to pay for your care in a nursing home.
That seems pretty harsh, to basically force somebody to spend all of their assets before being eligible for Medicaid.
It is harsh, but we have to realize that Medicaid is an entitlement program funded by the federal government. And as long as we're running government budget deficits, they're going to continue to make it more and more difficult to qualify for Medicaid. But there are options available. There are ways to protect and preserve your assets so you don't have to spend all those assets prior to going into a nursing home.
So what kind of planning can be done when this is a concern?
Well, because of the new laws that have recently been passed, the planning options have been reduced, but there still are options available. Some of those options include the use of annuities, gifting your assets to your children, although when you gift assets, there's other concerns that need to be taken into consideration. We can also develop special trusts which protect and preserve your assets should you end up in a nursing home.
I've heard that if you give away your assets within 5 years of entering a nursing home, you're not going to be eligible for medical assistance.
That's somewhat true, Susan. And we're getting into a very complex area of the law here, but let me try to make it as simple as possible. When you apply for medical assistance or Medicaid, the state is going to ask you if you have given away assets within the past 5 years. That is known as the look-back period. From the date of your application, they look back 5 years, and if you've given away assets, you must disclose that information. At that time, the state will look at those assets that have been given away and what the value is and calculate a penalty for doing so. That penalty must expire prior to the state with Medicaid stepping in to pay for your care in a nursing home.
I've also heard that the government will take away your house when you enter a nursing home. Is that true?
Well, it's not completely true. It's one of the myths that are out there when it comes to Medicaid planning. You have to remember your house is an exempt asset. But in order for it to retain its characterization of being exempt, for a single individual, there has to be a reasonable expectation of returning home. For a married couple, at least one of the individuals, one of the spouses, must remain living in the home and living in the community. If those qualifications are met, the house remains an exempt asset. However, if you can't meet those qualifications, if there's not a reasonable expectation to return home, or if one of the spouses is not continuing to live in the house in the community, that asset then becomes an available asset and generally has to be sold prior to eligibility for Medicaid.
So is it illegal to plan for Medicaid?
This is another myth that's out there, and no, it's not illegal to plan for the protection and preservation of your assets. This comes from a federal law which is commonly known as Granny Goes to Jail or Granny's Lawyer Goes to Jail. Even though this law is still on the books, this law can never be enforced because it has been deemed to be unconstitutional. So it's not illegal to plan for Medicaid.
Why isn't it a good idea to give your assets to your children?
Well, Susan, while many people think it's a good idea to give the assets to their kids and they're hoping that their kids will hold on to those assets until mom and dad might need them, that planning or that gifting is actually fraught with many problems. The first issue that we have is, what happens if we give our assets or give our home to our son or maybe our daughter, and then that daughter ends up in a divorce situation or even worse, in a liability lawsuit or having debt problems and having to file bankruptcy? All of those issues could cause that asset to have to be sold or mom and dad being kicked out of their home. And another issue that is faced by the children is capital gains, because when mom and dad give away assets, they also give away their cost basis, which means the kids, when they sell that asset after mom and dad have passed away, are going to end up paying capital gains on any growth in that asset.
So I can only give away $10,000 per year to each child, right?
Well, Susan, that's partly true and partly false. The reason it's false is because we can actually give away $12,000 per year per child, rather than just $10,000. But we're dealing there with federal gift tax law, and we have to remember that even though I can give away $10,000 to as many individuals as I want during a year and not have to pay any federal gift tax on that, one gift of $12,000 will cause over a 2-month ineligibility period or penalty period when it comes to Medicaid planning.
My revocable living trust will protect my assets if I end up in a nursing home, right?
A revocable living trust gives absolutely no asset protection. This is one of the biggest myths that's out there. When it comes to asset protection, we have to remember the rule of thumb is control or access to that asset. That's one of the main reasons why we establish a revocable living trust, is so that I can still control and have access to those assets during my lifetime. But as long as I have control and access of those assets, we have to remember that the state can also get access to those assets, which means they're going to have to be spent for my care. So the simple answer is no, a revocable living trust in no way protects assets if someone ends up in a nursing home.
What options do I have in planning?
Again, there are many options that are available. In our office, we try to put options together that will allow the client to receive the beneficial enjoyment of the asset, while not being considered the owner of that asset when it comes to qualifying for Medicaid.
Any final thoughts you'd like to share?
Well, Susan, you've seen from our discussion today that Medicaid planning is very complex. It's important that you sit down with a qualified attorney, an elder law attorney that practices in the Medicaid and medical assistance areas, and discuss it. And I also want to point out that timing is everything when it comes to Medicaid planning. It's more difficult if you're in the nursing home already or if you're about to head into the nursing home to do the planning. Some options are still available, but it's much easier and many more options are available if we do the planning early. So it's important that we discuss it as soon as possible.